For the record, will you please state your name?
Paul D. Ratzburg, Ratzburg.
By whom are you employed?
Pleasant Prairie Police Department.
In what capacity?
I'm a detective there.
Well, presently, what's your title?
Detective Lieutenant.
And on December 3rd, 1998, were you dispatched to any location within the village of Pleasant Prairie in Kenosha County in the state of Wisconsin?
Yes, I was to 9020 Lakeshore Drive or First Avenue.
And what was your purpose in being dispatched, or for what purpose were you dispatched to that location?
For a death investigation.
And upon your arrival at that location, what, if anything, did you see?
I saw a female in the bed, deceased.
That person was later identified to be Julie Jensen?
That is correct.
And then you commenced an inquiry or an investigation of that matter?
Yes, I did.
During the course of your investigation of that matter, did you have occasion to do a video of the crimes of the residents?
Yes, I did.
I show you this document or this item that has been marked as Exhibit 148, and I ask you if you can identify that.
Yes, that is the video that I took on December 3rd at the Jensen home.
Now, obviously, what you're holding there is not a video; it's a DVD.
You're correct. Yes.
And when you did the crime, the video of that scene, were you using a camera with a DVD thing, or was it a video recorder?
It was a video recorder.
And at one point, was that video transferred from VHS over to DVD?
Yes, it was.
And have you had occasion to compare the contents of that DVD to the actual crime scene, the actual scene video?
Yes.
And is that a true and accurate copy of the video that you took of the scene that evening?
Yes, it is.
Your Honor, request that Exhibit 148 be received into evidence subject to cross-examination and with the expectation of playing that to the jury at some time later today or tomorrow.
Judge, before admitting it, I'd request greater foundation in terms of when this was taken.
Okay, I don't have a problem with that. Detective Ratzburg, what time was it that you were dispatched to the Jensen residence?
I arrived there approximately 5:30, 5:45, somewhere within there.
And about what time was it that that video was taken?
I took that video before we moved the body, and then before we left and after the body was removed from the home.
So the body of Julie Jensen is portrayed in that video?
Yes.
And did you capture any images of the computer in the Jensen residence in that video?
I didn't capture any views that I recall of the computer. I do mention in the video where the computer was and that I recovered the computer from the den.
So by the time the video had been done, you'd already recovered the computer?
That is correct.
No further questions.
Are we breaking up direct and cross on this? Or?
Well, I don't, again, my purpose was just to lay the foundation for the video, and I guess if we're expecting that the cross-examination of this witness will take place at some later time, but I don't have a problem with counsel. I guess it's a good question. I don't have a problem with counsel cross-examining the witness on the points that were raised during this course of his direct examination.
I think that makes sense. I just have a couple of clarifying questions. So, Detective Ratzburg, maybe I misunderstood you, but so was this video that we will watch, was it taken at two separate times?
Yes.
And so what time is the first part of the video?
Looking at the video, I don't know.
Is there, does the video contain a time on it?
No, it doesn't.
So would looking at the video determine for you what time it was taken at?
I believe in the video I do state at certain points what time it is.
You don't have any independent recollection now as to when you began taking this video?
No, I don't.
How long is the first portion of the video? Are you able to tell us?
I didn't measure it.
Is there a clear, is it clear when you shift from the first part of the video to the second part?
Yes.
And how is that noted on the video?
I believe I stated.
What time is the second part of the video taken?
I know I say it on the video, but I don't recall offhand.
Is the second part of the video taken immediately before you leave the home for the day?
I'm not sure what you mean immediately, but shortly, yes.
How long after you finish the video is it before you left the home?
I don't know.
Do you have some sense of how long you'd been at the home when you began the video?
Yes, I know the video ends after 10 p.m., or we start to tape, and it ends after 10. So I was there approximately 5:30-ish, and so we were there till 10 o'clock.
How about the first part of the video? How long had you been there before you began taking it then?
I'm not sure.
You were, all this video that we will see was taken on December 3rd, is that right?
Correct.
You were back in the home on December 4th?
Yes.
Did you take any video then?
No.
Okay. So in terms of times that this video is conducted, it's your belief that when we watch the video, that will be explained to us?
Not entirely. I'm not sure what your questions are. There are times that I do give on the video, and maybe there's a clock in the video. I haven't looked at it that closely.
And if you say, for instance, I mean, let me just make something up. It's 7 p.m. and I'm recording the dining room or something like that. Would you have looked at your watch first and then done that? Is that how you determined what time it was?
I can't say it was my watch, but I'm sure I looked at a timepiece.
All right, well, that's all the questions I have before the video.
Nothing further, Your Honor. Like I said, we expect, if we have time, we're going to show the video to the jury later today.
You may step down.
Thank you. Your Honor, the state will call Gretchen Rosenke to the stand. For the record, will you please state your name and spell your first and last name?
Gretchen Rosenke, that's Gretchen Rosenke.
And Ms. Rosenke, by whom are you employed?
The state of Wisconsin.
In what capacity?
I'm an attorney with the Public Defender's Office in Racine.
And how long have you been with the Public Defender's Office?
About a year and a half.
So you're accustomed to being in a courtroom?
Yes.
Just not in that particular chair.
Exactly.
Do you represent a person named Aaron Dillard?
Yes, I do.
And do you recall receiving a letter from Aaron Dillard at some point?
Yes.
And what did he ask you to do in that letter?
He asked me to contact you regarding the Mark Jensen case.
And did you do that?
I did.
And how did that go?
It went pretty well. Actually, first, although I will say first, I talked to him. There was a call that we had to clarify what it was exactly, the information that he had. And then I contacted you.
And when you told me, and did you identify yourself?
I did.
And did you tell me who you represented?
I did.
And did I seem receptive to talking with you about this case?
Irrelevance and also speculation.
Rephrase your question.
Well, what was your impression of my reaction to what, to the fact that Mr. Dillard wanted to talk with me?
Objection, also speculation. Relevance.
Well, it doesn't call for speculation because the question is what his, her impression of his reaction. So the objection's overruled.
When I contacted you, it seemed like you were skeptical that I actually had any information.
I object to, unless Mr. Jamboys is taking the witness stand, this is improper.
Well, the question asked about her impression of his reaction, and you objected as speculative, and
I didn't see the answer is going there. I moved to strike, no foundation would be through hearsay.
Read the answer back again.
Answer, when I contacted you, it seemed like you were skeptical that I actually had any information.
Overruled.
What happened next?
You, as I recall, you asked me,
Objection here, sir.
Stepping off of the truth of the matter asserted, Your Honor.
Be offered to prove the truth of the matter asserted.
you asked me for an example of what Aaron had said to me, and I read to you a portion of the letter he had sent regarding how Julie Jensen was killed, and it seemed immediately that you were interested in what he had to say.
And were you, and did we then schedule an opportunity for an interview?
Yes, rather quickly thereafter, we had an interview.
And were you present for the interview?
Yes, I was.
Where did the interview take place?
That interview took place at the Kenosha County DA's office.
Well, wasn't there an interview in the Racine County Jail?
That's true. I'm sorry, the first one was right, yes, in the main floor of the Racine County Jail.
And who was present for the interview that occurred in the Racine County Jail?
It would have been you, Miss Gabrielle, Mr. Dillard, and myself.
Were you present during the entire interview?
Yes, I was.
Now, who was supplying information to whom at that point?
Well, at this point, it was Aaron Dillard supplying you with information that he had heard from Mr. Jensen.
At any time, did you see or hear either myself or Ms. Gabrielle provide any information whatsoever to Aaron Dillard concerning this crime?
No.
How long did the interview last? Do you remember?
I want to say maybe about an hour to an hour and a half.
During the course of this interview, was there any discussion about the letter that Mr. Dillard had sent to you?
Yes, there was.
And did you have the letter with you?
No, I don't. Well, I shouldn't say that. I don't recall if I did or not that day.
Well, you had a copy of the letter with you, correct?
Yes, I did.
And was it a legible copy?
No, it was very faint. The letter had been faxed to me by Mr. Dillard's wife, and the fax copy was not real clear.
So we couldn't read the letter?
No.
Now, at some later time, were you a party to a phone conversation involving Ms. Gabrielle, yourself, and Mr. Dillard?
Yes.
And you remember what happened during the course of that phone conversation?
Actually, I don't remember the conversation.
Exhibit 134, 139, Your Honor. You don't have it? Do you have Exhibit 139, Counselor?
I believe so. That went back.
You don't believe so, or you do?
I don't believe so.
We don't have Exhibit 139, do we, Major? No, it's not on the witness stand. You don't have it? Do you have the Exhibit 139 after, Judge? I have a copy. Well, okay, we'll use a copy until we... First of all, I'll show you what documents marked as Exhibit 134 and ask you to identify that document.
Yes, this is the letter that Aaron sent to me.
And you received that letter before you'd spoken to me, correct?
Yes, I did.
And now, do you recall whether or not during the course of the phone conversation between Ms. Gabrielle, your client, Mr. Dillard, and yourself, do you recall whether or not Ms. Gabrielle ever read a statement over the phone to you and Mr. Dillard?
Yes, I do.
And at the time that Ms. Gabrielle read the statement over the phone to you and Mr. Dillard, was that the interview that had occurred between Mr. Dillard and us still fresh in your mind at that time?
I believe it would have been at that time, yes.
And at the time that Ms. Gabrielle read the statement to you over the phone, did that seem consistent with your recollection of the interview that had occurred?
It did.
And did Mr. Dillard express an opinion as to whether or not the statement appeared consistent with the contents of the interview that occurred?
I believe he did.
Now again, during the course of that interview, did either Ms. Gabrielle or myself ever supply any information to Aaron Dillard?
No, you did not.
Did we supply any words for Mr. Dillard to use?
No, you did not.
Do you remember what date it was that you received the letter from Aaron Dillard?
Well, it wasn't dated, but as I said, I received it by fax, and I believe the date of the fax was August 21st.
And do you know what date it was that Aaron Dillard was removed from the Kenosha County Jail and placed back in the institution?
No, no.
But it was within a matter of days of August 21st?
I believe it was, yes.
At some point after the statement was read over the telephone to Mr. Dillard, was there another meeting between Mr. Dillard and representatives of the Kenosha DA's office?
Yes, there was. I believe you wanted to make sure that the statement was consistent, that you had everything correct, so we did have another meeting. This one was at the Kenosha DA's office, I believe.
And who was present at that meeting, if you can recall?
At that meeting, there was an investigator whose name I can't remember, but again, you were present, Ms. Gabrielle, Aaron, and then myself.
And there was another conversation about the circumstances surrounding the death of Julie Jensen?
Yes.
Now, at that time, did either Ms. Gabrielle or myself supply any information to Aaron Dillard?
No.
You're familiar as an attorney with the distinction between leading a question, a leading examination, and a cross-examination and a direct examination, correct?
Yes.
And just to tell the jury, although they've got a fair amount of experience on it too, but explain to the jury what your understanding of the difference is between a direct examination and a cross-examination.
Well, in direct, you want to ask more open-ended questions to allow for the witness to give more of a narrative, to just sort of flow with the information. And with a cross, you want to cut that off. You want to make sure that the question you ask is requires a yes or no response with little to no explanation given.
Now, what was the general form of the questioning that was used with Mr. Dillard? Was it more along the line of a direct examination or a cross-examination?
They were definitely open, and these interviews took quite a while because he would give a lot of background and information with the answers.
Was there ever any indication of Mr. Dillard being prompted in any way to provide one answer or over another at any time during the course of any of the interviews that you witnessed between Mr. Dillard and any representative of the state in this case?
No. As a matter of fact, you both.
Objection.
The objection is sustained.
No.
Well, okay, what were you going to say beyond that? As a matter of fact, what?
The objection is sustained.
Oh, but I thought it was sustained because it was non-responsive.
Well, no, it's sustained because she's commenting on summarizing the witness, read the question back again.
Before that first objection?
Yes.
Question, was there ever any indication of Mr. Dillard being prompted in any way to provide one answer over another at any time during the course of any of the interviews that you witnessed between Mr. Dillard and any representative of the state in this case?
And then could you read the answer up to
Just a moment. All right, go ahead, read the, well,
See, Your Honor, I guess I don't understand why the witness's answer was interrupted with an objection and why the objection was sustained, because the witness, as I recall...
Just a minute. My original ruling was based upon the fact that the witness was really summarizing rather than what her impression was, as opposed to quoting something which had been said. I'm having some second thoughts about it.
This witness's commentary, I don't have a problem with the question that was asked and answered, but in terms of, I think we end up in the improper bolstering area in terms of fitness of this interview.
Well, that's overruled. Go ahead.
Okay, so I'd request the last question go back to the witness and that the witness then just answer it.
The last question was, what were you going to say beyond that? As a matter of fact, what?
Just quite the contrary. You made it very clear to Mr. Dillard that if he wasn't being truthful,
Not offered, sir, and even if it is, it's an exception, a present intention. Overruled.
you made it very clear that if he wasn't being truthful in his responses, that would only be worse for him in the long run, and you made that abundantly clear. You never put any words in his mouth.
Thank you. No further questions. Mr. Almy.
Did you bring Mr. Dillard's file with you today?
I did.
I move for production of the entire file.
I would object to that, Your Honor. There's no indication that the witness has need of that file. It's that...
The problem would be that that would include matters pertinent to Mr. Dillard's case that have not been shown that the privilege has been waived with respect to that.
I believe that the privilege has been waived, and we can't have selective testimony from his representative that only covers what he wishes to have waived.
Your Honor, there's been no waiver of the privilege.
Just a minute. The objection is sustained.
This letter that you received, it was faxed from his wife?
Yes.
It wasn't mailed to you at all?
Not initially, no.
Was it ever mailed to you?
Yes, it was.
From whom?
I believe from his wife.
And when was that?
I'm not sure. It was well after, though. I know I had contacted Mr. Jamboys and given him a copy.
Has Mr. Dillard written you other letters?
Objection is irrelevant. It is also, it invades the attorney-client relationship.
Well, not yet. Overruled.
No, he hasn't.
He's never written you any other letter?
No, that was it.
About anything dealing with his case, he's not sent you any correspondence? Have you had any other occasion to see his handwriting?
Yes.
Do you know, is this his handwriting in this letter, or is it his wife's?
I believe it's his handwriting.
Do you represent Mr. Dillard in the pending cases in Racine County?
Yes, I do.
Did you represent him on his revocations in Kenosha and Racine?
Yes.
In both counties?
Yes, I did.
You've seen the memos from his probation agent regarding what she thought was an appropriate disposition of this case?
Yes, I did.
Ms. Rosenke, I show you it's been marked as Defendant's Exhibit 135. You recognize that document?
Yes, I do.
And that's Mr. Dillard's, it's a violation and revocation summary, is that what it is?
Yes, it is.
And it identifies all the violations Mr. Dillard allegedly committed while he was out on probation, correct?
Yes, it does.
This violation revocation summary is the kind of thing that a sentencing judge would take into consideration, right?
Yes, it is.
The judge would take into consideration Mr. Dillard's character, right?
Yep.
His danger to the public, correct?
Yes.
Whether he's had any period of crime-free living, right?
Yes.
How well he's done on probation or parole on previous occasions, correct?
Yes.
Number of offenses, correct?
Yes.
The judge can consider uncharged conduct, correct?
Yes, he can.
You are aware, I think it's the last, maybe the second to last page and last page of that document, Mr. Jensen, that the agent initially was recommending that he serve the maximum on all of these charges he was being revoked for, correct?
Yes, yes.
And that was 2 years, 11 months, and 21 days on 00 CF 1181,
Right.
and 4 years, 6 months on 02 CF 1286. Is that right?
That's right.
And then was there also another 4 months and 4 days on 05 CF 637?
It's not real clear from this, but
That's about, on the second to last page, about 1/3 of the way down where it says parole cases only. You see that?
oh, yes, I do. Okay.
And that was another 4 months, 4 days?
Yes.
Correct?
Yes.
The judges could impose these sentences consecutively, correct?
Yes.
So Mr. Dillard was facing more than 7.5 years, pretty close to 8 years potentially on revocation.
Close to that, yes.
The probation agent was recommending that he get that entire sentence, right?
Yes, she was.
And in doing that, she was considering both his history of charged conduct and his uncharged conduct, correct?
Yes.
And in this memorandum, she recounted all the allegations against him, right? No, not all, but the most recent ones, correct?
Yes, she does.
There was a Lori Brown who believed that Mr. Dillard had burglarized her house.
Objection, Your Honor. This is irrelevant how the agent summarized it, and
It's sustained.
Well, you told Mr. Dillard that all these things would be considered at sentencing, right?
Yes.
He was aware that the judge would consider this entire past history of conduct, right?
Yes, he was aware of that.
And you went over all these allegations with him?
Yes, we did go over it.
And for instance, there was an accusation that he had burglarized Lori Brown's home. and
objection.
so-
It's irrelevant, Your Honor. It's irrelevant. The witness went through all of them with him. This is going on for hours on the Mr. Dillard's
I object to the
sorry crime
speaking,
record.
I object to the speaking objection.
Finish up with it, Mr. Albee.
Well, one thing he was suspected of doing was burglarizing Lori Brown's house, right?
Yes.
And she accused him, according to the probation officer, because an antique teddy bear was stolen.
Objection is called for double hearsay, Your Honor, and it's irrelevant.
It's what Mr. Dillard knew.
What's that?
It's what Mr. Dillard knew would be considered at the time. What was reported is that Miss Brown said that an antique teddy bear that was valued at $4,500 had been stolen from her home, correct?
I believe so, yes.
That would be
I just don't see it right now in this.
That'd be page 3.
Oh, okay. Oh, okay, I see it now, yes. All right.
And she reported her belief that it was Mr. Dillard because she had told him about the value of this antique teddy bear, right?
Yes.
There were reports of bad checks from a Dennis Ritt, right?
Yes.
There were reports from Mr. Dillard's sister-in-law that Mr. Dillard had used their cell phone SIMS card without authorization, right?
Yes.
And that he had had a 115-minute phone conversation with an elderly woman in Janesville using that phone card, right?
Yes.
And in addition, he was currently charged with theft by contractor for his actions toward Cassandra Ivy, right?
That is the pending case, yes.
And Mr. Dillard's hoping to get no time on that pending case as a result of his cooperation here, correct?
Well, that's his hope, yes.
And that case has been put over so that he could testify in this case first, right?
Yes.
And has he acknowledged his guilt in that case?
No.
Well, just a minute. This evidence, folks, is being received not to show that these various accusations against Mr. Dillard are true, but was received, has been received so that you can consider it as material, things he may have been thinking about in deciding on his courses of action and how he ought to govern his affairs. You should not take this as truthful. So it really becomes quite irrelevant whether he's guilty or innocent, it seems to me,
Your Honor, the other
on this purpose, for this purpose.
And I object to any questions to this witness about conversations that occurred between her and Mr. Dillard, because that's an attorney-client relationship. It's
Except that as it pertained to the deal that was made in this case, I think it's been waived. So go ahead, but wrap this up, Mr.
Well, I would.
Please, wrap it up.
If you could go, it's 4 pages from the end, and there's a heading. Confinement is necessary to protect the public from further criminal.
Now, see, that's someone. All right, go ahead.
Mr. Dillard knows.
Wrap it up.
Well, Mr. Dillard was aware that the recommendation was confinement is necessary to protect the public from further criminal activity, correct?
Yes.
And when we go to the bottom paragraph, the agent felt that Mr. Dillard became excited when running games on others, correct?
Objection, Your Honor, that's irrelevant. That's the agent's perception.
That's sustained.
But you were aware that the agent was making all these recommendations.
Objection asked and answered.
It's got nothing to do with anything.
And now, you discussed with Mr. Dillard all these matters that the probation agent reported here and how that might affect his sentence, correct?
Yes, I have.
And you did that before and after Mr. Dillard made his claims against Mr. Jensen, right?
I'd have to check my file. The only reason I'm saying unsure is because I don't know that I had the revocation information when I first took the case in Racine, so I don't recall exactly when I received the revocation files for Kenosha and Racine.
Mr. Dillard's letter to you asked whether could get credit, right? Credit for testifying as Mr. Jensen, right?
Yes.
What he wanted to know is if he could get time served for that, basically, right? That he'd only do time on extended supervision and no more time in prison. True?
True.
Did you take notes during the first meeting that you had between the prosecutors and Mr. Dillard?
I believe I took a few.
And that was before the typewritten statement was produced, correct?
Right.
I'd move for production of those notes.
Do you have them?
They might be in my file, but isn't that protected by, isn't that my work product?
No.
They might be in my
Not in
file.
this litigation.
I'd have
Did
to,
you have your file with you, ma'am?
I do.
Would you take a look at it and see if you've got
Want me to
it?
just go get it right now?
Yes, ma'am.
Let me just apologize up front because it's not real well organized. It may take me a few minutes to find the notes. No, apparently I don't have any notes from that meeting.
Well, do you have them in some other location?
I don't think so. I think everything that I have on Mr. Dillard, well, no, that's true. I do have a separate revocation file, and that I don't have with me. I have his pending file here.
Judge had asked for an order that the notes, that Ms. Rosenke search for the notes, and if she finds them, that they be produced.
All right, go ahead. You'll be ordered to do that.
Okay.
Were you present here in this courtroom when Mr. Dillard testified?
Not on Friday. I got here today at about 20 after 9.
So you were here listening to testimony?
Part of it, yes.
That's all I have.
have no further questions.
You may sit down.
I have a motion relating to testimony.
We'll take it up at the next break.
Well, Your Honor, the next witness is going to be Kelly Jensen. It's going to be a lengthy witness. Perhaps we could take up the issue that Mr. Albee wants to take, and we can release the jury for a longer lunch break or something.
Let me ask that you return at 1 o'clock, and please don't talk about the case during the break. The questions that you asked about Mr. Dillard's representation that were not pertinent to the issues at hand here, I did sustain the objection because I don't think that there was a waiver of privilege with respect to other disclosures that may have been made in the course of the representation and in the course of the consultations. Now, what's up next?
I would just say this, Your Honor. I don't think there's been any kind of waiver of privilege of any sort whatsoever with respect to this case. The only thing that Ms. Rosenke has been asked to testify about are conversations that occurred between the defendant and the prosecution that she witnessed, and any conversations that she had with me, and none of those things are privileged. I've never asked Ms. Rosenke anything about any privileged communications whatsoever, and I don't have any reason to believe that either Ms. Rosenke or Mr. Dillard has waived any aspect of the attorney-client relationship.
All right, now what's the issue before the court right now?
I moved to strike her testimony. She was in the courtroom during the testimony. Mr. Jamboys, who she's not on his witness list, and he knew based on his comments during Aaron Dillard's testimony that he decided to call her as a witness, and then he does it all of a sudden, and she was in the courtroom the whole time, and he knew he was going to call her as a witness.
When did you find out about it?
When he said, I call the next witness, Gretchen Rosenke, that's when I found out.
Why didn't you object then?
I'm not objecting on notice grounds. I'm objecting that she was in the courtroom. I didn't know she was in the courtroom.
I understand that, but if you knew that she had been in the courtroom at the time that he called the witness, what am I misunderstanding?
I did not know.
You said he called Gretchen Rosenke, so why didn't you object then?
I didn't know she was in the courtroom listening.
I said, when did you find out?
When I asked her the question.
Oh, I'm sorry. I thought you said you found out when he called her and you realized she had been in the courtroom.
No, that's when I found out she was going to be a witness in this case. I found out that
she's on the list.
She's on my list.
Oh.
She was not on our list.
I was just presented with the consolidated list.
Was she on the list? I didn't know.
She's on the consolidated list.
Oh, I didn't even know that.
So you did not know that she had been in the courtroom until you asked her the question?
I did not know, and I don't know Ms. Rosenke, and I had even made an inquiry of Ms. Kavidra, and we were not aware that she was here.
She said she came at 20 after 9? Well, did you want to say anything?
Well, I don't know. I don't know that. I mean, I didn't. At some point this morning, I became aware that Ms. Rosenke was here, and I think it was toward the tail end of Mr. Dillard's testimony that I was telling Ms. Gabrielle, well, I think we need to call Gretchen Rosenke, and she said she's right here. And I think that was near the tail end of Aaron Dillard's testimony. So the witness was here, but I don't know that this witness in particular was instructed to not be in the courtroom. She represents Mr. Dillard, so one would think that she would expect to be in the courtroom. However, I don't think that there's just an automatic motion to strike or an automatic granting of that. I think that I don't think that her testimony should be stricken. I don't know that there's any indication that her testimony was influenced by what Mr. Dillard had to say. She was only asked about the communications that had existed before we ever got into the courtroom. And I think that if counsel wants to ask her questions about whether she was in the courtroom at the time that Mr. Dillard was here, the jury could plainly have seen that she was here. He can ask her questions, but I don't think the witness's testimony gets stricken just because there may have been this inadvertent violation of a sequestration order.
Did you want to respond?
The problem is Mr. Jamboys has indicated he knew she was in the courtroom during the examination, and that it was towards the tail end when Mr. Jamboys was going on at length about how it is he was going to call her to support various theories, and he expounded on those theories, and then he did his redirect on Mr. Dillard putting in those theories, and then he called her to confirm what had all been done in front of her. So I think it's problematic in this case, and that should be stricken.
Well, I do think that the court has to be very cautious about striking testimony. I mean, the jury is here to hear all of the admissible evidence, and anything that impedes that should be dealt with the utmost caution. And I think that it would be overkill to strike her testimony. I do think that the suggestion of Mr. Jamboy is that we can recall her to the stand and she can be examined about it, and the jury can decide for themselves how much weight, if any, to put on the conduct and what to make of it is appropriate. That would be appropriate, but striking the testimony, that just is a practice that stems from the excessive practice of keeping jurors from hearing evidence in criminal cases nowadays. So if you want to call her back for further examination, I'll permit you to do so.
What I would suggest is, because I have requested her notes, I also would request her a copy of the faxed copy of the statement, which I don't have, that she mentioned on examination, and any other notes relating to this event, if I could have those produced and then decide whether to bring her back based on all that.
That's fine.
Ms. Rosenke is here right now, and I guess I'd want to know, is this other file, is it back in Racine, or is it in your car?
The other file's back in the office in Racine. I don't have it with me.
Well, we've got time.
Okay.
All right, anything else?
Yeah, I had a mistrial motion. I just said I'd have a motion for later on. The court had instructed Mr. Jambois to stay off his medium argument, and he went back to it. It was clearly no appropriate basis, even arguable. It's not just an argumentative question. I mean, it's I think it goes beyond what's reasonably permissible, and he'd been told not to do it once. And the defense is the loser in that if he wants to just keep volunteering stuff like that.
Well, Your Honor, my understanding was that I couldn't write the word medium up there on the list that counsel had put together, and so I didn't. And that was my understanding of the court's order, not that I couldn't ever mention the word medium or seer again in my examination of this witness. And when the objection was sustained, I didn't ask any more questions about medium or seer, but I was going to write the words medium and seer up there until there was an objection on the grounds of it being argumentative. And by the way, that whole document is argumentative, but so I don't see how two more argumentative things are a problem, but the court ordered me not to, so I didn't write it up there.
One of the reasons that the case is supposedly 20 witnesses behind is because both of you gentlemen have been asking a lot of argumentative questions, and it needs to be curtailed, period. It's certainly not grounds for mistrial that he persisted, and the motion is denied. Anything else?
Then we'd be back here at 1 o'clock, Your Honor?
Who's the next witness? That'll determine when we're going to be back.
It was going to be Kelly Jensen.
Oh, yeah, you told me that. Yeah.
And but then there's a question about whether Ms. Rosenke can get her. There's no way you get your stuff and be back here by then. So it's probably going to be. So I would say it's going to be Kelly Jensen, Your Honor.
Okay. Is there going to be any haggling about that before we start with her?
Not that I'm aware of.
I don't know what Mr. Cafferty's intention is in terms of asserting privilege. If that, I know that happened at the forfeiture hearing. Obviously, that's all outside the presence of the jury.
Well, that's a good point, Your Honor. I guess I should have thought of that. But the fact is that if Ms. Jensen is going to assert a privilege against self-incrimination, that has to come outside the presence of the jury, and the offer of use immunity to overcome it would have to take place outside the presence of the jury. I would agree with Mr. Albee and I are in a rare moment of agreement.
Is he in the hallway now? with Mrs. Jensen?
You know, I told him that it was going to be after lunch, so my guess is not, but
Okay, well, if he isn't, then we'll do it at 1:45 and hope that he's here.
Your Honor, he didn't see Mr., the
right,
deputies
let's,
indicated he didn't see Mr. Cafferty, and I think that Mr. Cafferty expects to be back here at 1 o'clock. So,
Does anybody have a number to reach him?
Yeah.
Would you try to get him here at 1:45?
so you want us back here at 1:45 then?
I certainly do.
Okay.
Just before we go, just try to solve.
Sure.
If I reach him. Great. Hey, Pat, Craig Albee, 414-699. The judge would love to be here.
Thanks. One more thing. The privilege actually of Mr. Dillard was never actually asserted. And the reason I just bypassed that was because I assumed that if I asked the question of Ms. Rosenke, who was entitled to claim it for the witness, or if we had brought the witness back in, that it would have been claimed. And the statute also says that claims of privilege shall, as far as possible, not be made in the presence of the jury, which is what we're talking about right now, actually. And so I thought we had just taken a break. I didn't want to take another one. So I assumed that there would be a claim of privilege. Is that a fair statement, Ms. Rosenke?
Yes.
All right. Anything else?
No, Your Honor.
Okay, 1:45.
So you got